Good afternoon. I'm seeing people start to pop in. We're going to give it just another 30 seconds or so, and we will get started. All right. Good afternoon, everyone. I'm Jessica Griffith. I am part of the HFMA Colorado chapter. It's my pleasure to welcome you to our HFMA Colorado chapter webinar series. Make sure you follow us on our social media pages for more information about upcoming events and webinars just like these. We do want to take a moment to recognize our annual business partners. Their support allows us to operate our chapter and bring our members quality education and resources. We hope that you will take a look at them first when your organization needs services or support. A reminder that certification is included in your membership now. Study materials are all online, and all of your testing modules can be completed on demand at a time that's convenient to you. It's never been easier to get certified. If you're interested and want more information, contact the chapter for more details. Today, we will be using the chat box. If you have any questions for our speaker, go ahead and you can put those in there anytime throughout the webinar, and he will address them if he can as he goes, or we can make sure that we address any of those questions for you at the end of the webinar. There will also be polling questions throughout the webinar for continuing education. Please make sure you complete those polling questions. Today's webinar is brought to us by one of our annual platinum sponsors, PFC USA. Our speaker today is Nick Prola. Nick has been practicing law in the financial services sector for over a decade and has been the general counsel and director of compliance at PFC USA for the past 9 years, focusing on the defense of FDCPA, TCPA, and FCRA claims. He has presented on compliance, regulatory, and legal issues at the Association of Credit and Collection Professionals, ACA, National Convention, numerous Healthcare Financial Management Association conferences, the American Association of Healthcare Administration Management, Healthcare Business Insights, and numerous educational webinar sessions provided through accountsrecovery.net. Nick is also a member of the Inside Arms Consumer Relations Consortium and the ACA Regional Legislative Committee, working towards a fair and just regulatory scheme and preventing regulatory overreach. Join me in welcoming Nick.
Thank you, Jessica. Really appreciate being here. Really appreciate HFMA inviting me and allowing me to speak on this topic. I hope you find it enlightening. I realize that some of the participants or attendees of this webinar are not necessarily in the credit reporting space, but I think these things are impactful and can impact your decision-making at the very least. So I will go ahead and get started and let you know about new medical debt credit reporting rules. Jessica already did an introduction that was far too long, so I will skip that, but I do want to provide this legal disclaimer. I am an attorney, but I am not your attorney. I cannot give you legal advice. Any information gleaned from this webinar is just for informational purposes, and you should consult your own attorney if you have specific questions. So with that, we'll go ahead and get started. I've given credit reporting webinars before, and I'm always surprised to learn that some people are not familiar with the credit reporting process. And that's a kind of a nice area to be in because it's kind of a strange process. And if you don't need it, that's great. But I do like to start out with just a quick overview of what credit reporting is and specifically what credit reporting debt entails. Here you can see a quick overview. It lists your payments, your history, your loans, your current debts, any negatives that you might have, such as bankruptcies, if you've been sued, if you have judgments, if you have liens, and then, of course, if you have any debts. So those are all listed on your credit report. The technical reason for a credit report is to help creditors decide your risk level, and if they want to give you credit, how much credit they want to give you, or if they want to approve you for a loan. And then sometimes, of course, employers, rental property owners look at your credit to see if they want to do business with you or hire you. So that's a quick overview of what a credit report is. I'm sorry if everybody knew that, but a quick introduction never hurts. So moving on to regulation of credit reporting. There's the traditional regulation of credit reporting, which are the regulations that exist under federal law and state law. The first is the Fair Credit Reporting Act, which is very specific to credit reporting only. That preempts a lot of other laws that try to regulate credit reporting so that there's a kind of a uniform or easy to follow set of rules for credit reporting. So going back real quick, when we're talking about the types of debt that can appear on a credit report, the credit reporting agencies that I just mentioned, I'll go back to the previous slide, Equifax, Experian, and TransUnion, they have decided that the only things that will appear on a credit report are voluntary accounts. So things like fines or criminal matters or something like that, that somebody may owe money for, like restitution, those don't appear on a credit report, just to define that. But for your voluntary debts, the Fair Credit Reporting Act exists to make sure that the information on your credit report is accurate. And then it also exists to make sure that any data furnishers, which would be a collection agency or your rental companies, your credit card companies, anybody who's giving information that appears on a credit report, those are called data furnishers. The FCRA says that there has to be a reasonable investigation into a dispute received on a credit report. So if a consumer comes and says, hey, this is appearing inaccurate, or I don't owe this debt, as we'll see, those things kick off what is called the duty of reasonable investigation under the Fair Credit Reporting Act. The Fair Debt Collection Practices Act only governs third-party debt collectors. So any debt collector whose credit reporting also has a duty under the FDCPA to ensure that the credit reporting account is accurate and that it's marked disputed as a consumer disputes it, so that it appears as disputed when somebody else reviews that report. There's state regulations and rules that also govern credit reporting. Some states limit when an account may be reported and what kinds of debts could be reported. And then there's the Consumer Financial Protection Bureau, who is becoming more and more active in regulating credit reporting, especially medical debt credit reporting. They put out guidance, they create their own rules. Sometimes those rules seem to conflict with the Fair Credit Reporting Act and the FDCPA, and we'll talk about that in a little bit. But they have been very active recently, and especially under the Biden administration, they've been trying to hold credit reporting agencies like Equifax, Experian, and TransUnion to higher standards, especially when it comes to medical debt credit reporting. And now what we've had recently are credit reporting agencies creating their own rules to try to get ahead of the Consumer Financial Protection Bureau or the Biden administration, so that they don't have action taken against them for having inaccurate things on the credit report or impacting certain classes of people, certain socioeconomic classes of people with a disparate impact of credit reporting. And we'll talk about that in a little bit as well. So these new credit reporting rules, we'll get to in a minute, but traditionally, and in the not so distant past, there have been credit reporting rules that really treat medical debt credit reporting the same as every other debt. We started to see that evolve in IRC 501R, Internal Revenue Code 501R, which is only aimed at nonprofit hospitals. But they've created this class of collection action called extraordinary collection actions. They titled credit reporting an extraordinary collection action, and they said that nonprofit hospitals or the collection agencies they use have to wait at least 180 days to credit report. So there you see kind of the first instance of medical debt being treated differently as far as credit reporting goes. When you can essentially wait much less time, before credit reporting a non-medical debt account. States have started to adopt their own rules for extraordinary collection actions, which can include credit reporting. This includes timing requirements for the delay of credit reporting, just like IRC 501R. And some states are requiring notification to a consumer of the debt, and the new Regulation F under the FDCPA from the Consumer Financial Protection Bureau requires that consumers have an attempt to notify them of the debt before it can appear on their credit. Colorado, Nevada, Maryland are all states that have adopted requirements of notification prior to reporting a debt so that a consumer has an adequate amount of time to take care of it or look into insurance before it impacts their credit. And then credit reporting agencies did have a few rules aimed at medical debt, and you know, probably 5 or so years ago, they said, well, we're not going to allow anything that's less than $50 to appear on a credit report. I believe TransUnion, even more recently than 5 years ago, said, well, anything less than $100, we're not going to allow it to appear on a credit report. So you started to see a little bit of evolution in the rules impacting medical debt versus all other debts, and started to see them being treated a little differently. So we come to March 2022, the CRAs, TransUnion, Equifax, and Experian, they announced a joint measure that effectively results in 70% of paid medical debt trade lines being removed from a consumer's report. The 3 major components of this announcement were effective July 1st, 2022. Anything that's been paid in full after it was sent to collections was going to be removed. And I think that's not necessarily a bad thing when we're talking about the reason behind most collection agencies and medical providers' credit reporting accounts, and we'll get to that. The next thing they announced was that unpaid medical bills cannot be reported until they are at least a year old, and that's a year past the date of first delinquency. There's a little bit of discussion on whether that's the date of service or the date of first billing, but this is a much longer period of not being able to report than previously existed. This essentially doubles 501R. It doubles the amount of time that Maryland, for example, prohibited collections from appearing on a credit report for medical debts. And then starting in next year, and they said the early part of 2023, so probably before March 30th, 2023, the CRAs will no longer include on consumer reports any medical debt with an original balance less than or equal to $500. So your physicians, your physical therapy, your ancillary service providers, they generally have lower balance accounts, especially after insurance. Those are no longer going to be allowed to be reported by data furnishers. So that's a huge difference from every other medical debt, or sorry, not medical debt, every other non-medical debt that is allowed to be reported regardless of the balance, and we'll see what the impact of that will be. Here's a quote from kind of the joint CEOs of the 3 major credit reporting agencies. They say, "We are dedicated to fostering an economic health of individuals and communities. Unexpected expenses, such as the cost of an unplanned medical visit, can be a hardship for many families, and these changes, the new joint measures, realign our approach to medical collection debt reporting in a manner that is designed to help consumers focus on their personal well-being." Again, this is after a lot of pressure from the Biden administration and the CFPB to have less of an impact for consumers and patients throughout the country who are experiencing medical hardships. And they don't want it to impact access to credit, access to jobs, access to housing. But of course, this has an impact to everybody on this call who relies on the collection of accounts for the well-being of their businesses. This isn't the first time that the CRAs kind of took things into their own hands. In 2015, the 3 major credit reporting agencies entered into a consent decree with New York's Attorney General. And pursuant to that agreement, they agreed to institute a 180-day waiting period before medical debt would be reported on a consumer's credit. This waiting period was, again, meant to permit some extra time for patients to work with their insurance to make sure insurance was paying what it's supposed to. If they didn't provide insurance information on the visit, this gave them extra time to provide it. All of this, was kind of the first step to credit reporting agencies getting out ahead of perhaps actions by the New York AG, maybe further harsh regulations, because there was some concern that Equifax, Experian, and TransUnion were not reporting things accurately or responding to disputes appropriately. So I think this is kind of something that we could have all seen coming, but nonetheless is very impactful. So let's talk about each of these new rules individually, 1 through 3. And the first one is that paid medical debt will no longer be included on consumer credit reports. I think this is a positive for both, and there's a poll up. let me interrupt. There's a poll up. Do your collection vendors credit? Do you have your collection vendors credit reporting accounts? Yes, no, unsure. And we can see the results of that very soon. And then back to the first rule. No longer including paid accounts on consumer credit reports. As I was saying, I think this is a positive for providers, for collection agencies, and for patients. There's kind of 2 schools of thought behind the purpose of credit reporting a debt collection account. The first is that it's coercive, that you're reporting the account for the purpose of getting it paid. And then once it's paid, you really don't care what happens. The second school of thought is, well, credit reporting is supposed to give a holistic picture of a consumer's credit, whether their risk in lending that consumer further credit, getting their payment habits, and finding out if they're going to contribute to the economy or if they're just going to create more debt. I think most people now understand that collection debt credit reporting is coercive. The purpose behind it is to get the person to pay that account. No longer having it on the credit report after it's paid creates an additional incentive. We hear from consumers all the time who are only interested in paying accounts that are on their credit. So if there's one that's reporting and there's one that isn't, they will pay the one that is reporting first, and they'll only pay it if it comes off because they feel like a paid collection account is still a negative on their account, regardless of if the scoring models actually take that into place. And medical accounts are becoming less and less impactful on credit scores, the FICO score, the 8s and the 9s and the 10s that different lenders use to evaluate a consumer's credit. Medical debt collection accounts are becoming less and less impactful on scores. Yet still, consumers say they don't want it to appear as a paid collection on their account. They just want it removed completely, and otherwise they won't pay it. So I think this is really positive in terms of getting accounts paid, that we can remove them, collection agencies can remove them, and consumers know that they'll fall off if they just pay those accounts that are on there. The second rule is the extension of the reporting time frame. Again, we talked about when the year begins to accrue, and there's a little bit of confusion on whether it's from the date of service or from the date of the first bill. I think a very conservative approach and compliant approach is to use the date of the first bill. And if you don't know that, maybe using 30 or 45 days after the date of service is a good idea to begin to start the clock of when you can begin to report an account on somebody's credit. That's a medical. I think this is bad for both patients and collectors and providers. And the reason is, the longer that somebody goes without knowing about an account, and they might not know about the account if they don't read their mail, they don't answer their phone until it gets on their credit, the less documentation that person has if they want to dispute the account, the less fresh the information is in their mind. It's kind of the same reason a statute of limitations exists for filing a lawsuit, right? The longer that goes on, the less evidence is there, the less people's memories are there. So if you're only allowed to report after a year, I think it leads to less effective disputes and leads to less accuracy in trying to determine if that account was paid or if there's an issue with the account, and the consumer just has less to go on and less documentation that they probably kept. I think it's harder to get those accounts then resolved if those lingering questions on disputes occur. But if this leads to more accurate reporting, less involvement of insurance and less errors, I think it could be a good thing. So a few things to think about there, but effective July 1st, for any services provided after July 1st, those medical accounts can't be reported on the credit for almost a year. And then moving on to the final rule, I think this one is really tough. The removal of medical collection debt with an initial reported balance of less than $500 from the credit report in general just leads to loss of coercive credit reporting, and the loss of the risk analysis. If someone has one $500 account, the statistics show that they're likely to have many more, and up to, I think the average was, if somebody has a medical account in collections, they likely have 7 other accounts on their credit report as well. If we say those are all $400 accounts, that person has $2,800 in debt that creditors can't see, that lenders won't be able to tell whether there's a risk there. And these debts usually just don't go away. Consumers can still be sued for these accounts. So if there's $3,000 sitting out there that they could be sued on and garnished, and I know those things are starting to go the way of the dinosaur as well, but it's still a possibility. There are clients of ours who still engage in legal action. I think that does a disservice to the economy as a whole, to credit reporting as a whole, because it doesn't give a good picture of what's actually owed. And then, most importantly for those on this call, providers are just going to have such a harder time, and collection agencies are going to have such a harder time collecting these lowered amounts. So it doesn't seem like this is going to lead to, an evening of the medical debt field. It doesn't seem that it's going to spread the costs appropriately to those who actually incur the debts. We're all going to wind up paying more for our medical services because these $500 accounts are just going to be so much harder to collect. So those are the 3 new rules. What I'm going to jump into now, and probably what you're wondering is, first of all, is credit reporting effective in any way? And sorry, there's another poll that just popped up. Do the new rules make it more or less likely that you would allow vendors to credit report on your accounts, now that you know what all 3 of them are? So the question you're probably all asking, if you haven't already asked it or determined it for yourself, is credit reporting effective? Because why would you want to do this at all if credit reporting was not going to be effective? We have found through our data, all other variables being equal, and the way that we did this is we took a client who maybe had previously decided that they wanted to credit report all of their accounts. And then we took one of their offices and we would split up that office into credit reporting and not credit reporting, and try to do that across their portfolio and see what the impact was. And of course, we had their approval, and they wanted to see if this was actually something that was worth it. We found that the liquidation rate for accounts that were credit reporting was 2.08 times more effective, or a higher liquidation rate than non-credit reporting for medical debt specifically. And these were ancillary service providers, so they may have been absolutely less than $500 for their average balance. I think their average balance is probably around $260. So just within the same line of business, same geographic region, really the same patient mix, you can double your liquidation if you're credit reporting versus non-credit reporting. And I think that's really impactful. On the other hand, we did have portfolios of accounts where providers were credit reporting and decided, for whatever reason, be it reputational, litigation, those kind of risks, that they didn't want to credit report anymore. They didn't want their accounts on the credit report. They saw a 59% decrease in liquidation rate, and that was the average. Some less, some with lower liquidation saw an even higher drop. If we had clients with a really low liquidation rate, like 5%, and we stopped credit reporting, those went down quite a bit more than 59%. So I think you're going to hear various industry participants in the collection industry say that, well, they didn't really see a drop in liquidation or revenue when they stopped credit reporting, if they made that decision. I would challenge to ask for more specific data. I think you'll see that, for reasons we'll talk about a little bit, credit reporting is becoming more and more effective rather than less effective. So these new rule changes, I think, are really going to have a big impact, and we'll get into that. I have an anonymous question that I will go through right now. It says, in your opinion, will any of the new restrictive laws be reverted back to their previous state of 1 to 2 years ago, or will new regulations in the future continue to be more limited? I think that's a great question. And I'll talk about the CFPB, the Consumer Financial Protection Bureau, and the Biden administration's reaction to the credit reporting agency's new rules. And they said that the rules did not go far enough. And these were voluntary rules, again, from the CRAs. Nobody forced them to do this. This isn't codified in law. This didn't go through Congress. This was kind of the monopoly of the three major credit reporting agencies coming together and saying, I think this is a good way to avoid action against us. So I don't think things are going to revert back necessarily. I don't think the CRAs are going to reverse course and say, we were trying to avoid action by the administration, and now we don't think we're in trouble anymore, so we can go back and everybody can credit report all the medical debt. I think the opposite is true, and as long as perhaps this administration, the Biden administration, is in charge, the regulations, the rules are probably going to increase. Because again, the CFPB and Biden didn't think the CRAs went far enough in curbing what they call kind of the illness of medical billing in this country. So I think based on that, we're not going back. It's only going to get harder and harder to collect these accounts. Perhaps a change in administration, if more conservative leaders come into power in Congress or in the presidency, that could reverse course, but it's really hard to go back, and I think that would be not looked upon favorably by consumers. So my long answer is no, I don't think we're going back, unfortunately. I think we're stuck with these kind of rules in the future. I think there are things we can do to curb the expansion of regulation, and having all of you on the call involved in legislation and giving your opinions and showing with data how detrimental these impacts can be. I think that can help curb legislation in this area and get more on equal footing with the rest of debt collectors and the types of debt they collect. I don't think that medical debt should be put lower than automobile debt. I think medical debt is very important, and it keeps our providers in business able to provide services to people, especially in rural areas where there's not a lot of options. So I think that's something we all need to be involved in, get involved with our legislatures, and make sure they're not passing these bills without thinking about the unintended consequences of those. Good question. And if there's any questions at all, please shoot out and ask. I'm happy to address those rather than to just talk at you for the next half hour. So we talked about, in our opinion, that credit reporting is effective based on the data that we have at PFC. Why do we think credit reporting is effective? Well, I think number one, consumers are really transient. We might not have the best up-to-date information on an address or a phone number. So, when something negative appears on a credit report, the consumer gets alerted to that. They see perhaps a drop in their score, but the credit reporting agencies are supposed to alert consumers that some negative thing appeared on their credit report and give them an opportunity to address that and to dispute that. So it's kind of another communication channel. And that bleeds into number two, that traditional communication channels are just much less effective than they used to be. There is so much junk mail. People get so many spam and scam calls that they don't open their mail. They don't answer the phone. Emails might go into the junk mail as well. It's really hard to get a hold of people. So if we're expected to try to get a hold of somebody to pay this debt, and we're sending them by law envelopes that have nothing on them, and we're not allowed to call them and tell them that we're debt collecting, it's going to be really hard. So this is another communication channel to let that person know that there's an obligation out there for them. And I think it's so much more effective, especially if you don't have a good address, don't have a good phone number for somebody. You still have a way of getting them aware of this account. Number three is that finances change over time. So you may actually get in touch with somebody and get them to open their mail and to answer their phone and talk to them. They say, well, I can't pay right now because I'm not employed, or I don't have enough money, and I lost hours at work. Those things do change over time. And they might not remember 3 years down the road that they had a medical debt with provider A or hospital B. If it's on their credit report, though, and they know that it's continuing to stay on there because it is actually owed, when their circumstances change, they'll go back and take care of that if they want to, get a home or get an auto loan or get some other type of And even if not, if they're just interested in raising their credit score and they're in a better space now, they're going to prioritize accounts, as we see on number 4, they're going to prioritize accounts that are on that report. And if medical debt isn't on there, it gets moved to the back of the line. If you have another provider who is credit reporting and you're not, that provider is much more likely to get paid. So moving to the back of the line, I just think is not a fair way to treat medical debt, especially when you're talking about things that might not be necessities that people can take out credit for. These things all kind of bleed together with, it's hard to get in touch with people. When you do get in touch with them, they might not have the capability of paying, but their circumstances could change and they would have that capability later. But if you're not on the credit report, you're probably not going to get paid. They're not going to remember, because it's really hard to continue calling somebody for 5 years every week on a debt and not be accused of harassing them or getting told to stop calling. So this is a good way of kind of passively letting the person know, hey, we're still here. I know we talked to you before and you couldn't take care of it. We're still here when you can take care of it. Here's our information. And then especially for medical debt, especially for emergency services, there is more and more laws, especially in Colorado, they just came out with one, says you can't deny service for failure to pay. So if you have a medical debt that somebody hasn't paid, even if it's not necessarily an emergency, you're not allowed to deny service on the basis of their lack of ability to pay. So if you can't credit report and they're not opening your mail and they're not answering your phone calls and you can't deny service, there's really no incentive for that person to pay, and they might not even know. Let me see if there are any other questions. There we go. Does not look like we have any questions now. If you guys have any questions, again, please feel free. So, credit reporting maybe sounds really great, given all of those things we talked about and rising to the top of the line and making sure consumers are aware of the debt. But there is a big cost to credit reporting. So first, each CRA, TransUnion, Equifax, Experian, they charge their own fee to report an account. So you're going to have that cost. I don't know the exact amount. It's probably in the 10 to 50 cent range, depending on the CRA per account for getting that account on the credit report. And then if you're doing it all 3, you're tripling that cost. eOscar, which is a requirement to sign up for, and that's the disputing part of credit reporting, where they compile all 3 credit reporting agencies' disputes into one portal, and then you respond to those disputes through the eOscar platform. You're charged money for each dispute that you respond to and that you receive. So there's another cost. Those typically are 50 cents to $1 for each dispute. Human resources for dispute response and quality assurance to make sure you're reporting accurately, depending on how many disputes you receive and how many credit reporting submissions you make. You might need 3-4 full-time employees if you're a collection agency to continue to credit report in a responsible manner. And then the regulatory and litigation risk is becoming more and more great. Regulatory, for the most part, is centralized with the CFPB, and they can come out and do investigations and do consent decrees or settlements or fines for companies who are not reporting accurately or not doing investigations into disputes. And then, of course, litigation risk under the FDCPA, the FCRA for inaccurate reporting. And then something that's probably more pertinent to this audience, though, is the reputational risk. There are constant news stories. I just saw one on NPR about somebody who said their life was being ruined because they had medical debt on their credit report and they weren't able to get credit. You don't necessarily want to be the provider who is on the credit report, preventing people from having a good life or getting housing or taking on a loan or something. But you balance that with still being able to collect the amounts that are due and owing to you in a rightful manner. So those are the costs and the risks. Talking about regulatory and litigation risk, I think this is really interesting. So I've been in this defense space on the creditor side for about 10 years. When I started my legal career, I was on the other side. I was working for a plaintiff's firm and represented plaintiffs for FCRA, FDCPA, TCPA claims. When I started in 2010, the FDCPA was way at the top of the list. And as you can see, in 2013, it still was. And that's really your debt collection, you're being inaccurate in your communications, or you're harassing people, those kind of claims. And you can see that those have gone way down over the course of the last 10 or so years. And FCRA claims have actually surpassed them in 2022. And I think that's incredible. Because FDCPA claims are so much easier. There's statutory damages. There's a lot of different things you can allege. FCRA claims, you're really just alleging that the dispute investigation was not reasonable. And we'll talk about why that's hard to defend in a little bit. But I think it's amazing that the FCRA has surpassed what used to be the most commonly filed federal claim in the country, which was an FDCPA claim. And then you can see even in the past 2 years how much this has changed and how much FCRA cases are becoming more and more popular. So those are based solely on credit reporting claims. And then just another visualization that you can see, FCRA is taking over. It accounts for almost half the claims in 2022, when in 2016 it was only 21% of the claims. So I think that's just going to continue to grow and grow. Collection agencies are getting more compliant, and FCRA claims, as I'll talk about, are really hard to defend. So where a plaintiff's firm is going to go, where our regulator is going to look at, they're going to look at the things that impact consumers the most. And if we're not calling people too often, you're having good conversations with consumers when you're collecting debts, you're treating them well, those FDCPA claims go down, and that's what's happening in the industry. So plaintiffs' attorneys need to look elsewhere to feed their families, to put food on their table, and FCRA claims are becoming easier to do. So why are FCRA claims so difficult to defend? I think it's because the FCRA, really the only thing you can sue a data furnisher for, which is a collection agency or a provider who's credit reporting, the only thing you can sue them for is failure to conduct a reasonable investigation. Courts determine that this is generally a factual inquiry for a jury, so you can't get rid of it by saying, well, look, we allege that we did do a good investigation and it was reasonable, so let's make this case go away. They say, well, a jury has to determine, after you do discovery, after you take depositions, the jury just determines whether it was reasonable or not. And that's really expensive to defend. You don't want to go to a jury trial for every FCRA case you get, because it just becomes prohibitively expensive. Also, FCRA cases certainly can, if there is a violation, they can have actual damages. If you're credit reporting inaccurately, if you have the wrong amount, or it's already been paid, or you're not marking it as disputed, and somebody is denied credit because of that, or doesn't get a job because of that, that has a lot of actual damages. There are monetary results and emotional results from that, which can be compensated from an FCRA claim. And then also, as a collection agency defense attorney, I want to be able to take care of these cases on my own, and FDCPA cases really don't involve the original creditor that much. When we're talking about FCRA cases and the information you're reporting, I'm getting that from my clients, the providers. So I might have to involve them to find out if they, reporting information correctly, if their information in their placement files had an issue. So it just becomes a lot more involved, and I don't want to involve my clients in litigation. That's not a good. So those are kind of the reasons why FCRA cases are growing, and why the other types of claims under consumer collection protection statutes are shrinking, because they don't have these necessarily, don't have these elements to them. So if you can't credit report under $500, or you've decided these new rules just make it impossible to credit report and it's not going to be effective, or you're scared about the litigation risk, which I think is fair, what are the alternatives? So how do you replace the inability to contact consumers? How do you replace the leverage you might have, or the coerciveness of collecting through credit reporting? It's really hard to do. I think there aren't a lot of options, but number one is getting modern consumer communication preferences logged and then using them. If somebody says, I want to only communicate by email to your provider, to your business office, and then you place it with a collection agency, I'm hoping that you want that collection agency to use that communication channel and when they're communicating. It's a much higher probability of getting a contact with the consumer if we're using the channels they want to communicate in. Modernly, everybody has email on their phone. Everybody can get text on their phone. You can use chat nowadays on websites. So I think making sure your vendors and yourselves are using modern communication preferences, finding out what those preferences are, and then communicating in that manner, I think is part of the issue of overcoming the lack of notification that an account is credit reporting if somebody's not going to open their regular mail and not answer their phone. Number two is flexible payment options. If somebody can't pay at the time, they might not be able to pay the whole thing, but maybe they can start paying $20. At least paying $20 gets you in front of that person. It reminds them this debt exists. It creates a continuing relationship. So I think payment plans and different methods of payment that are maybe non-traditional, like using Venmo or Apple Pay or Affirm, that might open up a can of worms with financing. But getting people the most easy way or efficient way to pay that they like to use, and then getting them just involved in any way in paying is much better than, I can't afford $988, so don't call me anymore. I'll call you when I can afford it. They forget about it for the next 5 years, and they never see it again because it never credit reports and they have a CSCOM. And then number three, discounts. I think what we're really going to have to do is start selling consumers on why to pay. And part of that is offering a discount that, if you pay now, if you set up a payment arrangement now, we can give you this amount of a discount. Just becoming salesmen, and because there's no negative consequence to not paying, and they might have other bills that they prioritize because they are credit reporting. I think getting that person sold on a reason to pay, and I do think most people want to pay their just and knowing debts, and it can be an issue of prioritization. So moving yourself up the line, getting people on board with paying you, and giving them an incentive to do so, and do it more quickly than not, I think that's going to be a real key. But I am not, I'm not saying these are the only alternatives, but these are the things that I think can help replace some of the lost revenue from those accounts you're not credit reporting, and at least get in front of the consumer. I don't think these will fully ever replace the incentive and the coerciveness of credit reporting. I could be wrong. I could, modernization of contact channels and payment options and discounts, maybe that does resonate with consumers, but I really think unless there's an impact, they're going to prioritize other debts. So back to new CRA joint measures, just to go over them one more time. July 1st, 2022, you have to remove, or the CRAs will remove, medical debt that has been paid in full from credit reports. I think it's also a good idea if your vendor or you are credit reporting, you're going to want to not send updates on those accounts and report them as paid. Because the CRAs, I know, are not perfect. They handle millions and millions and millions of records every day. Something will get missed, something will get dropped off, and I could see a lawsuit occurring because you reported something as paid or continue to report something as paid that the CRAs miss deleting, and then you'll be alleged to treat the consumer unfairly because you're not following this joint measure. So it's important to know that and not rely on the CRAs, and also make sure your reporting is as accurate as it can be. Unpaid medical bills cannot be reported until they are at least 365 days past the date of first delinquency. Again, I think the safest way to do this is to wait 45 days from the date of service, maybe 30 days to 45 days from the date of service, then start your clock, then report at 365 days if you're still reporting. And then, of course, not being able to conclude consumer reports on any medical debts with an original balance less than or equal to $500. This is something that I think is perhaps open to a creative solution. And it really does depend on how your billing works. And if I can give a little background on this, probably about 5 years ago, there was litigation in the collection space that had to do with how accounts are credit reported. And the way accounts were credit reported or could be credit reported were you would get a $100 account for a date of service in January, and then a $100 account for date of service in February, and a $100 account for maybe the next day or the same day. But those were all treated as separate debts. So consumer attorneys said, hey, this is unfair. You're acting like this person has 4 accounts, but it's really owed to one creditor. So shouldn't it be reported as one account? Those lawsuits weren't necessarily unsuccessful, but I believe that the industry was able to prevail, and court said, no, you can report accurately as long as the reporting is accurate, that this account is this amount of money and is related to this date of service. You can report those individually. But the consumer attorneys may have given us an idea of how we can maybe overcome this $500 reporting threshold by consolidating accounts. And I think you have to be really careful about this. And I don't know that just saying, hey, we have $500 of accounts with this one provider, so we're going to report them and use this date that we've just come up with, or that we're using the oldest date or the newest date. But if you start maybe using your billing as a ledger, and you kind of are continuing to add up the amounts owed, and then you send kind of a final bill, maybe that's a way of overcoming this $500 reporting threshold, where, if you have 10 accounts that are $50, you can't report any of them. But if it's in a single ledger, perhaps you can report that as a $500 debt and get it on the credit report. Again, I am not giving legal advice. This is just thinking out loud, giving some information on ways to maybe creatively think about that. But consumers are going to be aware of these new rules, right? I already know of consumers who have reached out, even though these rules haven't gone into effect, this $500 one specifically, and say, hey, you can't report this because it's under $500. Well, it hasn't gone into effect yet, so things are still reported. But consumers, especially those with medical debts who have had medical debt in the past, are becoming more and more savvy. They're able to research these things online very easily. The CFPB puts out bulletins saying, hey, be aware of this. The credit reporting agencies will say, hey, be aware of this. So the more and more these consumers are aware of these new rules, the less incentive they have to pay. So I think any creativity you can get to get these debts, to get consumers and patients aware of these debts, to get them on the credit report if they're actually owing, I think those are good things to be thinking about. I am done a little bit early, I realize, but I would love to take any questions that anybody has. We do have a final poll. Do you see credit reporting as a significant reputational risk? Yes, no, I don't know. Have any of you had instances of reputational risk that you can trace back to credit reporting? I think those are interesting questions. If there are no further questions, I hope you enjoyed this. I hope it was educational and gave you an update that you can use and start thinking about things. My email address is nprola@pfcusa.com. Website is down there as well. Feel free to reach out at any time if you'd like to discuss anything. I can't give you legal advice, but we can have a nice chat. Thank you very much.
Thank you, Nick, so much. We really appreciate you giving your time today and sharing your expertise with us. I want to thank all of our attendees as well for giving their lunch hour to us today. The presentation is available for download in the chat box now. So if you want to try and download that before you go. I also emailed that out to our registrants a little earlier today. So it is in your email, hopefully. I was going to mention that the contact information was on the screen and Nick took care of that for me. Certificates will be sent out after attendance and participation is verified, probably within the next 2 weeks or so. And then I do just want to let everyone know to mark their calendar for our spring symposium, which is coming up April 12th through the 14th. That will be held down at the DoubleTree DTC here in Denver. And we really hope everyone will be able to make it. The committee is working really hard. They've got a great agenda that's shaping up right now, and we're all very excited to share it with you. With that, I don't see additional questions that popped up either. So we will give everybody 10 minutes back for their day. And have a wonderful Wednesday, everyone. And thanks again, Nick.
Thank you, Jessica. Thank you, everybody. Bye.
Bye-bye.